Please rise. Court is now in session.
I strenuously object. A legal podcast brought to you by the Pittsburgh law firm of Flaherty, Fardo is now in session.
All those seeking information about the law and legal matters affecting the people of Pittsburgh and the Commonwealth of Pennsylvania, half-baked opinions, and a dose of self-indulgence are invited to attend and participate.
I want the truth! You can't handle the truth!
The defense strenuously objects.
You would!
Call the first witness.
All right, hello and welcome to I Strenuously Object. This is attorney Bill Rogel, partner in the Pittsburgh law firm Flaherty Fardo, and I am flying solo today to do a little bit of cleanup, I suppose, as much as anything about one of our prior podcast episodes and to answer a question that was raised in it. So, without a long monologue to introduce us, and thus without any further ado, we did have a question. So this relates to, we had done an episode a while back on whether or not you should continue treating with a doctor if you've been a victim of medical malpractice. You should go back to the same doctor. And there was a question about one of the points we made there that was asked that I would like to have the opportunity to answer and expand upon a little bit. So, Mike, what was that question?
Before I get to that, let me mention that if you'd like to listen to that previous episode that Bill is referring to, it's titled Understanding the Certificate of Merit and How It Can Make or Break Your Medical Malpractice Case. That's one of the three questions that we answered in that episode. And that can be found on pghfirm.com's podcast page, in addition to all the podcast apps you're used to. But anyway, the question that we got after that episode was this. You talked about a doctor being a, quote, fact witness. Aren't all witnesses fact witnesses? What does that even mean?
This is a fair question, and it's one of these, legal terms of art where we use things in a way that kind of maps onto the English language generally, but not always, right? So in some level, yeah, sure, every witness is a fact witness.
That's the fact, Jack! That's a fact, Jack!
But the distinction that was being made there is between an expert, right, an expert witness and a fact witness. So an expert witness, you call and you specifically have to tender their credentials to be able to render an opinion about the case at issue, or in the case of doctors, right, the treatment at issue, medical causation, whether someone deviated from the standard of care. You need an expert for these things, and there's a specific legal process for introducing someone as an expert, getting them qualified in court as an expert, which then allows them to render opinions within this context. Now, I do want to note there is a little bit of a difference, I would say. I suspect you could teach an entire course, right, in some sort of journalism school about fact versus opinion and where these lines are drawn. But for these purposes, we don't necessarily mean exactly the same thing by opinion versus fact as we do in other contexts, right?
Well, that's just like your opinion, man.
So someone could, and I think in most of the rest of the world, we describe opinion versus fact as, an opinion is something that exists like objectively outside the subjective person who's speaking, right? So whether or not someone is a good driver, that term good, that's an opinion. In my opinion, that's a good driver or a bad driver. If, on the other hand, I'm saying the car was going 53 miles an hour, that's a fact, right? In the way that we normally talk about this.
It's science.
On the other hand, unless you were staring at the speedometer, generally in the legal context, if someone is going to tell you that the car was going 53 miles an hour, that's going to be what we in the kind of evidentiary world call an opinion, right? Because they're basing that not upon direct observation, but rather they're culling together based upon other data, other facts, things that are outside of their personal knowledge to reach a conclusion. Right. And so you end up needing an expert to do an accident reconstruction. And that expert uses the data for the speed cars are traveling and how long the tire marks are and how quickly a person can stop when traveling at a certain speed. And they're able at the end of that to render an opinion, often in the form of a range of how fast the car was going. Now, the thing that they're rendering their opinion about is a fact, right? But that is within the kind of legal world that we live in, more along the lines of an opinion. And the general rule is that witnesses are not supposed to testify about their opinion, right? You can testify about what you saw, what you heard, what you firsthand experienced, but you're not supposed to testify about your opinions, or like the conclusions that you reached based upon what it is that you saw or heard or experienced firsthand, because that's usually the jury's job. You are stepping on the toes of the jury if you go from this car was traveling at faster than the speed limit to this car was traveling in a dangerous and unsafe manner. As a witness, that's not my job. That's the jury's job to decide if, based on what I told them I saw, they believe that the car was traveling in an unsafe manner. So one thing I want to talk about in this regard, there's that scene in My Cousin Vinny, and we talked my affection for My Cousin Vinny is documented on this podcast. It was my number one pick in our legal movies draft podcast. But there's a scene when Mona Lisa Vito, right, Vinny's fiance and Marissa Tomei's character, is on the stand, and the kind of key moment when she realizes, based on the picture that she took, that in fact the Buick Skylark that the defendants were driving could not have made the tire marks in question.
The defense is wrong. Because there is no way that these tire marks were made by a 64 Buick Skylark. These marks were made by a 1963 Pontiac Tempest.
Objection, Your Honor. Can we clarify to the court whether the witness is stating opinion or fact?
This is your opinion?
It's a fact. The car that made these two equal-length tire marks had positive traction. You can't make those marks without positive traction, which was not available on the 64 Buick Skylark.
She says it's a fact. When you hear her go on to describe how she reached this conclusion, there's some opinion involved, right? Like whether or not anyone would confuse a Buick Skylark with a Corvette. She may be right, but this is quintessentially the sort of expert opinion that an expert would be making in trial, right? I looked at this image, I combined it with my expertise, my knowledge that goes beyond the normal person's knowledge of automotive history and the way cars work to look at these and reach a conclusion. Within the confines of what we call an opinion, that's an opinion. And the reason that's important, all of the stuff that came before that, right, where they had to argue whether or not she was in fact an expert, and she tells you, my father was a mechanic, my brothers are mechanics, and then she talks about her own, or all of that stuff where they quote unquote voir dire the witness. You wouldn't need any of that if that were a fact. If she were just stating fact, you don't need to make her a quote unquote expert first, right? Because facts exist outside of that expertise and don't require the expertise. The whole point in the law of making someone an expert is to loosen the rules to allow them to give you opinion testimony. So that's kind of what I want to talk about a little bit, is this distinction between a fact witness and an expert. Who is kind of fundamentally an opinion witness. So, as I mentioned before, generally the law frowns upon allowing witnesses to give opinion testimony. And generally, when you call a non-expert, you want that non-expert, that what we call a lay witness, you want their testimony to be limited to what they saw, what they heard, what they experienced themselves and have direct firsthand knowledge of. There's a ton of evidentiary rules, whether it's the rule against hearsay or whatever they are, that basically stop that witness from delving into what they know or what they have inferred based upon knowledge outside of the kind of four corners of what they experienced. There are some places where lay opinion testimony is still admissible. And in fact, in Pennsylvania, at least, there's a specific rule of evidence. It's Rule 701 that covers that, right? Rule 701 reads, if a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is A, rationally based on the witness's perception, B, helpful to clearly understanding the witness's testimony or to determining a fact at issue, and C, not based on scientific, technical, or other specialized knowledge within the scope of Rule 702, which is the rule that covers expert testimony. So it's interesting to note there are places where, when it's within the competency of the witness, and because it's a lay witness, that means not like their professional competency, but like their general competency as a human being walking around in the world. They're allowed to render an opinion when that opinion would be helpful. So one of the obvious examples here is estimating the speed of a car that you see. Generally, the law says if I witness an accident, I have enough knowledge generally as a layperson to give you a ballpark estimate of how fast I think a car was going. I'm not sure how good people actually are at this, right? But we've decided over the course of any number of years and cases that this is evidence a person can give, even though to some extent it's an opinion. They didn't see that speed, right?
Is it enough for them to just say he was going too fast?
Well, too fast is interesting, right? Because it depends on what you mean. If you want to say, I think he was going faster than 35 miles an hour, and 35 miles an hour is the speed limit, then in that case, yes, the witness is able to say, look, I think it was above that number, at least if it was relatively obvious. Now, too fast imports a certain overall judgment about speed for the conditions or what is or is not safe, and that's probably lay opinion that is considered not helpful to the jury. It's the jury's job to decide how fast is too fast. But I can give evidence that leads to that estimate of speed. If I can't estimate speed, how can I help the jury understand whether the car was or wasn't going too fast? So there are times when a lay witness is able to give opinion testimony, but that is the exception, not the rule. And the other important thing with a lay witness, unlike an expert, is when they're able to give an opinion, it has to come from what they directly observed. An expert is allowed to consider those things in forming an opinion. And when I say an expert, right, like I said, there's a process where you ask the court, and you will usually have a chunk of time where you establish the expert's credentials and whether or not they have sufficient training or experience or knowledge to be helpful to the jury in this regard. And then opposing counsel will have an opportunity to actually interrupt your direct questioning, as you saw in My Cousin Vinny, right? And do voir dire of the witness, where they can now ask their questions about the witness's expertise and their knowledge and their background and whether or not they are in fact a witness, at which time the court is then asked to make a decision, right? Is this person sufficiently qualified to be an expert and offer opinions in this case? When the court says yes, what that does is opens up the expert to rely on more than what the expert firsthand saw or heard, experienced, right? We most often see this, though not exclusively, in the case of doctors, in medical malpractice cases or any personal injury case where you need a doctor to come in and talk about the injuries and the outcomes and what caused the injuries and what the future prognosis is. And those things aren't coming typically from that doctor's firsthand knowledge. This is usually not someone who treated the plaintiff at issue. They don't have direct factual knowledge of anything in the case, but they're allowed to look at the medical records and the deposition testimony and X-ray images or MRIs, whatever they're allowed to look at. And this can include things that would be otherwise inadmissible, things that are hearsay, things that other people said, things that people who saw or investigated the accident have submitted in some sort of evidence or report. Heck, this can include a police report, and police reports generally are not admissible. If you want the information that's in a police report to get into evidence, you usually have to call the police officer to testify about their actual investigation. But if you have an accident reconstructionist using statements in a police report, and that accident reconstructionist, the standard here is, are you relying upon the sorts of materials or information that generally people in your field of expertise are relying upon? And if that answer is yes, then you're allowed to form your opinion based upon even things that are otherwise inadmissible. And so when you have an expert, that expert's able to take a much broader scope than their own firsthand personal experience and consider all of the evidence, even inadmissible evidence, to reach an opinion about what happened in the case. So when we said fact witness, what we mean is, hey, there's a difference between a doctor who treated you in terms of how you have to act during discovery, whether you have to submit an expert report. So in Pennsylvania law, if you're going to have an expert testify at trial, the general rule is you have to have that expert submit a signed written report that sets forth what their opinions are and what the basis for those opinions are. In a lot of other jurisdictions and federal court locally, you're allowed to do discovery about the experts, right? You can ask them questions. You can even do a deposition of an expert before trial. That simply isn't a thing that Pennsylvania state courts do, right? So all the more reason we need to have a written report first, so you don't show up at trial hearing an expert offer an opinion, and this is the first time you're hearing it, and you have no chance to cross-examine it or understand its bases and get your own expert to rebut them. Again, talking about My Cousin Vinny, we saw that here, right? Mr. Wilbur, the expert in tires, shows up with no prior notice and no prior written report given to the defendants, and then testifies against them in a criminal trial.
We compared the tire marks outside the convenience store with the rear tires of the defendant's car. They're the same model and size tire.
As much as I like a lot of the realistic touches in My Cousin Vinny, there is a 0% chance that this evidence gets in, right? You can't go to trial without an expert and then halfway through the trial decide, oh, I found this guy, he's going to come testify now. The court's not going to let that in. Once they do, of course, it's pure chaos, and now Vinny's also left finding an expert on short notice, and thank goodness he does, right? But the rule is your expert has to submit this written report, covers the opinions, cover the facts they rely upon, gives everyone the opportunity to know in advance. A fact witness, and even a fact witness who's going to offer opinions, is not required to submit a report of that kind. Treating physicians are kind of up in the air. It's a much bigger question about what they'll say if they end up being called in to testify as fact witnesses, and even if they're able to offer opinions, it's just a totally different process. Talking about treating physicians, it is worth pointing out that there are rules against the defendants in a case, assuming it's the plaintiff's treating physician as an injury case, are entitled to do discovery with respect to treating physicians, right? They can do a deposition, they can request the medical records, typically do, but they are not allowed to independently contact them. The rules do not allow a defendant in any case, but in an adverse party, in a medical malpractice case or a personal injury case, to call your doctors and ask them, hey, if we call you as a witness, what are you going to say? Tell me about this patient. Not allowed to do it. There are formal discovery things that can be done with respect to a treating physician, but there is a separate prohibition against contacting them directly. So anyway, I hope this helps answer the question. I hope this tells us a little bit more about what I meant when I said fact witness, which does sound like a weird redundancy in the context of a medical malpractice case. Okay, thank you for joining me on this solo and hopefully not too long-winded edition of I Strenuously Object. Hopefully you got to learn something or enjoyed our time together in some form or fashion. If so, please subscribe, rate, and review the podcast. Tell your friends or your enemies to check us out. Please keep coming with those questions. It's easy for us, right? It gives me free content. So if you have any questions for our Mailing It In segment, any feedback for the podcast whatsoever, email us at iobject@pghfirm.com. You can see us on Instagram at I Strenuously Object Podcast. And wherever you're encountering our content, there's probably a comment section or someplace where you can ask your questions directly. We'll try to look out for them. We'll try to answer them if we can. If you have any other questions or have legal needs of your own, please visit Flaherty Fardo at our website. That's at pghfirm.com. And until next, some parting advice.
They named it San Diego, which of course in German means a whale's vagina.
No, there's no way that's correct.
I'm sorry, I was trying to impress you. I don't know what it means. I'll be honest, I don't think anyone knows what it means anymore. Scholars maintain that the translation was lost hundreds of years ago.